What's up, everybody? Welcome back into another episode of The Lawyer You Know. We are back on Brian Kohberger. We watched the motion hearing, at least the portion of it that we could watch that was open to the public prior to judge's orders on those motions to continue and third-party culprit. Will Brian Kohberger be able to do all of that? And why? Sometimes more importantly, we get a little taste of what Judge Hippler feels about this case and these motions. Let's get to it. All right. It's been a crazy busy day today. Sorry I'm a couple minutes late. I was also looking at these and I basically only skimmed them. So I have not read them in their entirety, but so many people have messaged me about how spicy they are, how angry the judge seems basically, and how he really feels about this case and really thinks about this. But I'm not really surprised with either of these rulings. This is what we expected. This is what I talked about on the prior video of how I expect him to rule on these. I really knew nothing about, oh, they changed all the names and handles. Why is that? That's so weird. Everybody's like, we're trying to adjust to this. That's crazy. So I really didn't know anything about the alternate perpetrators, AKA third-party culprit, meaning pointing the finger at somebody else. And we didn't get to hear a lot of the argument, but it seems like there's a full order on it, 7 pages. I see there's some redactions, so I'm really interested to read that. And then the motion to continue, that denial, which, spoiler alert, he denies both of these motions. That denial is 20 pages long. It's unusual to deny a motion to continue in it to be that long. So we're going to take a read at that one as well. So let's start with this redacted order on defendant's order of proof regarding alternate perpetrator. Introduction. By the way, we've been covering the Karen Reed trial for 8-9 weeks. And it's been a while since I've sat on screen and read 30 pages to you, but we're going to do that today. We're going to take our time. We're going to get through both motions in full. We are going to break down both motions in full, but hopefully my voice doesn't get completely shot and I'll have to pause for some drink breaks and, of course, answer your questions throughout. Here we go. The state previously moved in limine, meaning to remove, or to add, to be able to do something or to block somebody from doing something, seeking to preclude the defendant from offering or arguing alternative perpetrator evidence without first satisfying the applicable evidentiary standards. So as we know, anybody that followed the Karen Reed case, or maybe you don't know, in order to even point your finger at somebody else and say he did it or she did it, you have to pass some muster, right? You've got to pass some, you got to have a burden to prove I have enough here to be able to point the finger. You can't just speculatively point the finger at everybody and confuse the jury and say it could have been Abraham Lincoln. Maybe he could have come back and done this, or the car could have been shot off into space, right? You're not allowed to use things like that. It has to be legitimate. You have to clear evidentiary standards from the judge before you're even allowed to put it in front of the jury. The judge, you hear us say, is the gatekeeper. That's what it means. The gatekeeper means what is and is not allowed to come before the jury for the jury to even consider, because not that a jury's stupid, but if you tell a jury, hey, you should consider this, or hey, this person is an expert, you should listen to what they say and take it seriously, that's going to affect the way the jury does things. And you want to make sure that you're only putting very legitimate and reliable things in front of a jury. In accordance with the court's subsequent order on the motion, the defendant filed his offer of proof and evidence in support, identifying 4 individuals as the potential alternative perpetrators. 4. So sometimes when you see a lot of alternative perpetrators, it means none of the arguments for any individual one is that good. Not always, but sometimes. The defendant conceded at oral argument that at this point, his proffer is not sufficient to pursue an alternate perpetrator theory at the outset of the trial. So this order should not be a surprise to anybody that could hear the arguments, which we couldn't because they were not public, but to anybody that could hear those arguments that was in the courtroom, this should not be a surprise because the defendant even admitted it at this point, at the outset of the trial. Context is very important to this order. But requests latitude in cross-examination of the state's witnesses to try to establish additional evidence to satisfy the Meister standard. Might be Meester. We're going to go with Meister. The court concludes that at this time, the defendant's alternate perpetrator proffer is inadmissible under Meister as it is irrelevant and or excluded by 403. However, this does not, okay, and this is the big thing. Yes, the judge says no, Brian Kohberger is losing all these motions. Oh no, it's so bad. But this does not foreclose the defendant from cross-examining law enforcement regarding the reasonableness of their investigation and its follow-up on plausible leads. What is the judge going to consider a plausible lead? That's the big question that remains open here. The standard. So what is the standard? How do we get there? Trial courts have broad discretion in the admission of evidence at trial. A trial court acts within the bounds of its discretion when it, 1, correctly perceived the issue as one of discretion. Number 2, acted within the boundaries of its discretion. Number 3, acted consistently with the legal standards applicable to the specific choice available to it. And number 4, reached its decision by the exercise of reason. The analysis. The seminal Idaho case on the admissibility of the alternative perpetrator evidence is Meister. Prior to Meister, a defendant wishing to present such evidence at trial had to first present proof of connection with the crime, such as a train of facts or circumstances as tend to clearly point out someone besides the accused as the guilty party. Remote acts, disconnected and outside of the crime itself, cannot be separately proved for such a purpose. Meister clarified that the Idaho rule of evidence, rather than the more onerous Larson standard, control alternative perpetrator evidence admissibility. Under these rules, evidence is relevant if it has any, okay, so it's even a little more vague, if it has any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. That might be confusing to you, but it is a pretty vague and broad statement. Idaho Rule of Evidence 403 governs the exclusion of relevant evidence and permits a court to exclude evidence if its probative value is substantially outweighed by a danger of unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. We all know what 403 is. We have all heard 403 before. It's just basically, does the probative value of this evidence get outweighed considerably by unfair prejudice that may come from it? That could make even potentially probative or material evidence inadmissible at trial. That's what 403 is. Meister further offered the following guidance on applying these rules and determining whether proffered alternative perpetrator evidence is relevant and admissible. If the defendant proffers evidence which merely tends to mislead the jury that another person committed the crime, or the evidence is not relevant because it does not tend to make the defendant's involvement more probable or less probable than it is within the trial court's discretion to find the evidence inadmissible. So that's how they can break it. If it just merely tends to mislead the jury, that's the important part. Does it tend to mislead the jury that another person committed the crime? Not prove to the jury, but does it mislead them? Which is an interesting take, right? Mere inferences now, these words are important, that another person could have committed the crime will most likely not be relevant. First off, that doesn't mean it's always not relevant. It says most likely not be relevant. But another person just could have committed the crime, right? Inferences that it could have committed the crime. And if relevant, will still be subject to the limitation provisions of 403. Because the reason 403 is important is if it's unduly prejudicial because it confuses the issues or misleads the jury. Those are the ones they're focusing on here. Does just saying, oh, Peter could have done it because he also Googled, the manhunt in the Idaho killings. Could it be Peter because he Googled Brian Kohberger's name? Could we put Peter on this alternative perpetrator list, right? It's just not enough there. You're going to need more than that. And it's within the judge's discretion to determine if what the defense provides is enough for them to make this argument at trial. Here, the evidence defendant has proffered purporting to establish the 4 individuals as alternate perpetrators abjectly fails to meet the Meister standard. Namely, the evidence is entirely irrelevant. Nothing links these individuals to the homicides or otherwise gives rise to a reasonable inference that they committed the crime. Indeed, it would take nothing short of rank speculation by the jury to make such a finding. 3 individuals were each socially connected to one or more of the victims, interacted with one or more of the victims at social events in the hours prior to the homicide. We're going to jump past this. Lived within walking distance of the crime scene and were familiar with the layout of the victim's home from prior social events. So one of the big things, and one of the reasons the defense probably wants to put some of these people on as alternative perpetrators, is some might see that as more than the connections Brian Kohberger has, right? That might be why they really want to make these arguments, because they're saying, look, these other people have way more of a connection to the victims in this case than Brian Kohberger does. Brian Kohberger has no connection, right? That's what we've heard, at least publicly speaking. All right, after I'm done with this paragraph, I am going to go back up and read that footnote because it's important and it's a big chunk, but I just want to finish to this scene so we kind of finish this thought. And we're familiar with the layout. Okay, I already read that. While perhaps this evidence could suggest an opportunity to commit the crime, which no doubt is an opportunity shared by dozens of other of the victims' social circles. So he's saying you can't just say because they were friends or because they knew each other that that's enough to make them an alternative perpetrator. There has to be more than that, because then it's dozens, if not hundreds of people that they come into contact with at these college parties or in their classes, et cetera, et cetera. There is no compelling evidence that any of them had a motive to kill the victims, much less physically harm them, or a means to do so. Okay. Motive, opportunity, intent, means, those are all important things. And if we think back, because we just broke down the Karen Reed case, the people like Higgins and Alberts that they wanted to make third-party culprits, they were there at the location. They walked right by his body, potentially. Brian Higgins may or may not have been flirting with Karen Reed and wanted John O'Keefe out of the picture. Or when they were saying Colin Albert had gotten into arguments with John O'Keefe in the past, and Colin Albert had a tendency to fight, the ability to fight, to beat him up. Brian Higgins, boxer, whatever, getting in that stance, what he did afterwards. Those are all of the indications that add on top of the fact that they knew John. And it sounds like Hippler saying, okay, so these 3 or 4 individuals, they knew the victims. They were at a party with them. They had been in the house, et cetera, et cetera. It's just not enough, is what Hippler's saying. Further, there's no evidence connecting them to the crime scene. They have each cooperated with law enforcement. I don't really love that line. So if you don't talk to cops, that makes you guilty. Providing DNA samples, fingerprints, and allowing searches as requested. Notably, lab testing has excluded their DNA from samples taken from the crime scene and victims. Okay, so that's the first 3 individuals. Let's read this footnote now. Where does it start? Here? Nope, here. In addition, the evidence largely consists of inadmissible hearsay. The defendant contends, however, that under Chambers, hearsay tending to establish third-party culpability may be admissible to protect a defendant's constitutional rights to a fair trial and to present a defense under the 6th and 14th Amendments. So while that is true, where there is some grace given and some gray area extended for certain hearsay statements and some defenses, you can't base your entire third-party culprit defense on, hey, I heard this guy say that Johnny was at the party and was acting real creepy following them around. And, I thought he took some pictures of them and whatever. It just can't be somebody saying somebody else said something or heard something, right? It's got to be more than that. What Chambers actually held, so that's not good. When a judge says, the defense says a case stands for this, but what it actually says is, that's not good. That's the judge saying, you're wrong. And the way you're citing this case law potentially is misinterpreting it, misusing it. That's not usually good when a judge says that about you as a lawyer. What Chambers actually held is that an accused has a due process right to the admission of exculpatory hearsay, in example, a confession by a third party, provided it is accompanied by persuasive assurances of trustworthiness. So that's different than, maybe somebody from jail saying, hey, Johnny was in prison with me and he confessed to committing this crime. That, if it's, again, with the persuasive assurances of trustworthiness, and you'll notice here, this motion so far is filled with words that it's very important to get their definitions right. And when he sets out the definition of judicial discretion at the outset, that tells you, I, as the judge, am going to use my discretion to define these words for you. Okay? That's really important. By the way, make sure everybody hits that like button because YouTube is doing all sorts of weird things. Also, check your subscription. Make sure you are still subscribed to the channel, especially if you're following this case, because I have a feeling it's going to heat up now. The testimony rejected by the trial court here bore persuasive assurances of trustworthiness and thus was well within the basic rationale of the exceptions for declaration against interest. Because if somebody's confessing to a crime, that's obviously a declaration against interest, right? That testimony also was critical to Chambers' defense. In these circumstances where constitutional rights directly affecting the ascertainment of guilt are implicated, the hearsay rule may not be applied mechanistically to defeat the ends of justice. So he's saying you cited it wrong. It does not say you can use it to try and prove these third-party culprits, et cetera, et cetera. That's not it. This was a confession, totally different circumstance. The judge is differentiating these cases. Somebody just said it is affecting their notifications and it unsubscribed them. So make sure you guys check all that stuff and have hit the like button, etc. In other words, Chambers indicates that due process requires hearsay rules to bend to evidence that directly is a bearing on the determination of guilt. Now, I would argue that if there's a real third-party perpetrator, that is a direct pointing to guilt, okay? And we've got to understand that. Now, it's hard because there's so much blacked out that I don't know exactly. We don't know all the details for this, and we just have to realize that's a big part of this case. There's a lot we don't know. As the court later stated, the accused does not have an unfettered right to offer evidence that is incompetent, privileged, or otherwise inadmissible under standard rules of evidence. Oof. It sounds like he's saying you're reaching and I don't like it. Okay, what is footnote 2? The three of the individuals were each socially connected. So this footnote where he explains maybe who those three individuals are, that's gone. All right, then we get footnote 3, which live within walking distance of the crime scene. The fact that these individuals lived within walking distance of the crime scene is not probative evidence, given that the perpetrator drove a vehicle to the crime scene. Further, none of these individuals drove a vehicle matching the description of the suspect killers. So what I would say to that is, sounds like the judge is making some factual decisions here, because that's the state's argument. Have we agreed or stipulated to the fact that the perpetrator drove there? Because, you know, the Uber driver or whatever it was drove there potentially. Couldn't the perpetrator have walked there? Do we know that he drove? I know the Elantra is connected and that's law enforcement's feeling, and law enforcement has gone with that and they feel like that's how they're connecting, using the car data, phone data, whatever it may be. But like, has it been a decided fact that the perpetrator drove there? I don't think so. And I don't think the judge should make that decision. Maybe the defense has stipulated that and I just don't know it, but I don't love that. I understand if he's saying it's thin, there's nothing here, you can't do this, it's too much of a reach, it's confusing and misleading to the jury, that's fine. But I'm not so sure that that fact has been stipulated to. The fourth individual did not know the victims, but had a passing connection. I'm wondering if this is the DoorDash driver. I'm wondering if the fourth individual, I don't know. I'm not saying it is. That's just what came to my head. To one of them while noticing her shopping at a store approximately 5 weeks prior to the homicides. Just kidding. Clearly not the DoorDash driver, right? Somebody that just saw her shopping at a store approximately 5 weeks prior. Like I said, I haven't read these motions in full. He followed her briefly out the exit of the store while considering approaching her to talk. The DoorDash driver, I believe, was also a female. So this is maybe somebody they're trying to say is a stalker or creepy or something. He turned away before ever speaking to her. This event was captured on a surveillance camera. So this just gives you the idea of what defenses do, right? Defenses are scouring all these security cameras. They see a guy walk up and they're like, that guy looks like a creep. Maybe he's an alternative perpetrator. Obviously, you're going to need more than that. I don't know if they have more, but that's kind of interesting to me. The event was captured on surveillance camera. This individual subsequently cooperated with law enforcement, providing his phone number and a DNA sample. As with the other alleged alternative perpetrators, lab reports exclude his DNA from the samples taken from the crime scene and the victims, and there is no evidence connecting him to the crime scene. So yeah, some random security footage putting him in the vicinity of one of the victims at another time, and the fact that he opened his mouth, which Judge Hippler is saying such a great thing. If he wouldn't have opened his mouth, there's no way it ever comes back on him. The defense decided to use that against him. Like, oh, he liked her. He looked at her, liked her, wanted to talk to her, didn't end up talking to her because he was too scared. Maybe he's a creep. Maybe he forced his way in and, committed these crimes. That's where the defense is trying to go with this, or at least so it sounds. They're not going to be able to. Collectively, defendants' proffer with regard to these 4 individuals fails to give rise to even an inference that they committed the crimes or otherwise make it more or less likely the defendant was the perpetrator. Therefore, it is irrelevant under 401. So he's not even getting to 403. He's saying it's not even relevant. I really don't like the comment about the car. Like, if we're going to say for sure they had to be driving a white Hyundai, like, I don't love that. That's got to be proven to the jury. Defendant has provided no probative, admissible, significant evidence of motive, ill feelings, means, presence at the scene, or any other connection to the crime that could possibly move the ball to the extent it supports an alternative perpetrator theory. So we'll go more with the guy on the surveillance camera. I completely agree with the judge there. That's just nowhere near enough. And again, compare and contrast this with the Delphi case, right? Where I feel like they had a lot more to make those arguments. Again, a lot I don't know about that case, so I'm not going to dive in too much because the trial wasn't videoed. And to Karen Reed, even, you have motive potentially. If you don't agree with the motive, that's fine. They're trying to use Aruba as a motive, right? I'm trying to get with your girlfriend feels like a better motive than Aruba. And, opportunity, means, right? They're guys that physically could have done it. They were at the crime scene. So at least those arguments should have potentially been allowed, or at least were a lot closer than it seemed like in this case, more of a closer call. At best, the defendant's proffer can give rise only to wild speculation. And he's using this language that's harsher than it needs to be potentially, but also used in case law. You'll see judges use words like wild speculation because there's case law that says it can't be wild speculation. So if you're trying to connect it with certain cases, that's why you would do it. That is possible. Any one of these 4 individuals could have committed the crimes, which is inadequate under Meister. Again, mere inferences that another person could have committed the crime will most likely not be relevant. In other words, it is not sufficient for a defendant to merely offer up unsupported speculation that another person may have committed the crime, which is all the defendant has done here. Even if there was a shred of probative value in the proffered evidence beyond wild speculation, it is excluded under 403. So he says it's irrelevant, but even if it's not irrelevant, it's unduly prejudicial when compared to the little probative value. As the 10th Circuit noted regarding alternative perpetrator evidence, it is not sufficient for a defendant merely to offer up unsupported speculation, even they don't say wild, that another person may have done this crime. Such speculative blaming intensifies the grave risk of jury confusion, and it invites the jury to render its findings based on emotion or prejudice, which obviously we don't want. Likewise here, presentation of the proffered alternative perpetrator evidence would pose a great threat of confusing the issues because it would force the state to defend against a nebulous allegation that perhaps these individuals were involved. And again, we saw that in Karen Reed trial 1, how it almost felt like it was a defense. And the case law says we only want the state to have to do that if it's legit and there's enough evidence for a good third-party culprit defense. This foray would lead the jury astray, turning its focus away from whether the defendant, the only person whose actions are on trial, committed the charged crimes. Some of his language and the way he's writing it makes me think he almost never thinks a third-party culprit or alternative perpetrator theory should be allowed, which I don't like that. I don't like that. We have rules and laws and case law in place where it is appropriate in a lot of different circumstances. This might not be one of them, and that's fine. But the way he's writing it, man, Ann Taylor has got to be rethinking her decision to get rid of Judge for Judge Hippler, because this is a much tougher judge. It also presents and I really like a lot of aspects of him, but this one, it's like, seems like he's very rarely allows it. It also presents a threat of unfair prejudice, as it would invite the jury to blame unrepresented persons for heinous crimes when there is not a scintilla of competent evidence connecting him to the crime. And again, if that's correct here and true here, I would love to read what connections they have for those 3 other individuals. But even Ann Taylor's admitting, I don't have enough here yet. So I get why the judge is coming down so hard. Finally, it would do nothing more than waste the precious time of the jury and the court in what is already a scheduled 3-month trial. Ugh, 3 months is going to be long. Nonetheless, the court's ruling does not preclude the defendant from confronting and cross-examining the state's law enforcement witnesses regarding the thoroughness of their investigation, particularly in following up and ruling out leads generally. I like that, right? I like that he's going to allow that. Let's read this quick footnote. At the state notes, none of the four individuals drives a car that could be mistaken for a Hyundai Elantra. Again, that's you telling the defense they have to stick with the state's theory, right? That's what you're saying there. That somebody couldn't have hidden away inside a cabinet or the attic of the house or jumped on the roof. Like there's other ways that you could get out of the house besides with a car, but I don't know. Indeed, the Idaho Court of Appeals recently found in an unpublished opinion that questioning a detective about failing to follow up on other plausible leads was relevant to the alternative perpetrator analysis. We agree. God, I'm having back issues. Got a little ice on my back. Move around. We agree with Emerson that a relevant line of inquiry would be to question scope and breadth of the investigation and to explore on cross-examination whether plausible investigative leads about third parties were ignored or overlooked. And again, that's kind of like the Bowden defense. That's allowed. That's good. It further stated that this line of questioning may not include inquiries about the investigation of specific third parties absent satisfying the Meister, noting while evidence challenging the thoroughness and reliability of the investigation might be probative, questioning whether law enforcement investigated specific individuals with no connection to the crime provided no probative evidence. Moreover, with no connection between the evidence and the crime, there is no explanation or justification for the questioning, and it would not help the jury answer the only question in this case, whether Emerson ended the life of James. The court will apply these same parameters at trial regarding the defendant's cross-examination of law enforcement. He may inquire as to the reasonableness of the investigation, including investigating and ruling out other leads. He's not, however, permitted to question law enforcement about the investigation of any specific individual as a potential alternate perpetrator without first raising the matter with the court outside the jury's presence. Based on the foregoing, the defendant's offer of proof regarding the alternate perpetrator is denied. But the door is still cracked open, right? Door is still cracked open, but it's denied. Okay, let me answer some questions. Here from Anchorage, Alaska. Hashtag, I want Peter's hair. Awesome. All the way from Alaska. I don't know if we have a lot of viewers in Alaska. Orders, paras aren't justified. Does it count? Orders, paras aren't justified. I don't know what this means. Sorry. Read the footnote. We did that. Hey, Peter, asking from the UK, does the third-party culprit ruling apply if the third party isn't named, i.e. unknown third party, or still not allowed? It can be unnamed, like if you have a video of a guy that's 6'5" and the defendant is 5'6", you can say, this guy is the third party. We think he did it. He's walking into the crime scene and walking out within the time period. He's got a weapon in his hand. Like, yes, you don't have to necessarily know the party, but it can't be like the boogeyman, like somebody else had to have done this. You know, you've got to have something proving it. Don't want to be the guy who brings bad news, but the chat name issue is only happening in your channel. I just went to another live channel and it was regular. Easy fix for the next live, probably. John or Kelsey, can you guys look at that? Because that's not a great thing. That's pretty rough. Does it say it was a close call, Miss Taylor? LOL. No, I did not see anything about it being a close call. Maria said other channels are having problems too. Okay. I don't know, but let's check it out because that would really suck if it was just something happening for us. I'm dreading how the defense will malign the survivors of this horror. Yeah, I don't know. I think you can be ready for everything. You can be ready for literally anything in this case. Been a member since day one. That's awesome. D. Fritz. So allowing a robust cross. Yes, it seems crazy. But maybe every single witness, the judge will allow a robust cross in this case. Okay, a bunch of people are saying it's happening on other channels too. Okay, thank you for easing my anxieties. Bev, with the judge's ruling regarding alternate perpetrator theories, I assume the defense has to shift their focus to dismantling FBI forensic case. This is my official request to bring on Easter to regularly discuss. Yes, we will see. I don't know, man. I think they're going to have a couple different theories. But I just... There's so much we don't know. I mean, half of these, wait till we get to the motion to dismiss, right? This is a 6-page motion and we have half a page, 1 page. So one of the 6 pages is completely blacked out, basically, completely redacted. What is that? That's a little less than 20%, maybe 15%. It's completely blacked out. So there's going to be a lot that we just don't know and haven't seen yet in this case. That's my theme, is we're going to learn a lot at trial. This judge seems very adamant that this is going to be an open trial. This is going to be a public trial. This is going to be streamed. We're going to get to watch. We're going to get to see exactly what happens. All right. Welcome to all the new members, and thank you for Crystal for gifting a membership here. All right, now we are going to get to this motion to continue. The judge is denying it, which motion continues usually get granted if there's a legitimate reason. He's kicked this one and moved it around a couple times, change of venue. It's gotten delayed here and there. It was supposed to be a speedy trial and wasn't. So from the perspective of a continuance, this isn't really like a first continuance. It was even supposed to be this summer, and they kicked it to August or the end of July, beginning of August. So, and he also indicated that it's not going to get continued. So this really shouldn't be a surprise. Surprise to me is how long this order is. And by the way, even on a simple motion to continue, where they had the entire hearing open to the court, we still have redactions. 1 redaction, 2 redactions, 3 redactions, 4 redactions, 5, 6. I mean, look at all these redactions. Pages, literally pages, probably 10 to 15% of this motion, again, has been redacted. We'll see how surprised we really are when we get to court. All right. Before this court, the defendant's motion to continue. The basis for the motion is threefold. First, he asserts that the volume of discovery continues to pose a challenge to his counsel's ability to timely and meaningfully review all of it. Second, he asserts that there is penalty phase investigation and preparation that still needs to be done. Third, he asserts that recent and forthcoming publicity on the case is highly prejudicial. Maintaining the current trial setting under these circumstances, he argues, will render any conviction and sentence unconstitutional. The state responds that the defendant's motion is untimely, and he has failed to show either good cause for continuing the trial or prejudice that would result from maintaining the current trial setting. Oral argument on the motion was June 18th. Court finds the continuance is not warranted as defendant has not shown that there is good cause to continue the trial or that its substantial rights will be prejudiced by proceeding to trial as scheduled. Here's the footnote for that. The defendant filed some of his supporting materials ex parte. While the court is not convinced that much of the filing is necessary or appropriate to be treated as ex parte, how about that? It's like, you shouldn't have done this. You didn't even do this right. The court will nevertheless, in an abundance of caution, issue a redacted and unredacted version of this order, with the state only receiving the redacted version, giving that the court is denying the defendant's motion. So the redacted parts, at least now we know, are because of the defendant's ex parte filing. Again, he goes over the discretionary standard here, and let's get to the analysis. Under Idaho law, defendant seeking continuance must demonstrate the substantial rights will be prejudiced absent a continuance. Case law says unless an appellant shows that his or her substantial rights have been prejudiced by reason of a denial of his or her motion for continuance, appellate courts can only conclude that there was no abuse of discretion. The judge necessarily requires a great deal of latitude in scheduling trials. The burden of assembling the witnesses, lawyers, and jurors at the place and time for trial counsels against, not talking about lawyers, it's telling you or advising you against continuances except for compelling reasons. There are no mechanical tests for deciding when a denial of a continuance is so arbitrary as to violate due process. The answer must be found in the circumstances present in every case, particularly in the reasons presented to the trial judge at the time the request is denied. Where a continuance is sought based on the late disclosure or discovery of evidence, the alleged tardiness of the discovery must be shown to so prejudice the defendant's case preparation that a fair trial will be denied. The bare claim that additional investigation could have been conducted is not sufficient to demonstrate unfair prejudice so as to support a motion continued. Yeah, because if you really wanted to, every lawyer in every case could say, if I had more time, I would be able to do this, do a better job. Additionally, where a continuance is sought for the potential receipt of evidence from further investigation, the motion is properly denied if it's based on speculation. So you can't just say there might be more evidence. Time out. I need more discovery. NY Babs, you going to let me make you an app? So I don't know if you're the one that emailed in, but John saw the email, and I will say it piqued his interest. If that was you that emailed in, I think John is going to be reaching out to you to talk about that, what it means, hopefully to vet and be able to confirm you're real and know how to do this. Not saying you're not. We just don't know a lot of people on the internet, don't want to get ourselves into some trouble there. But I think John is going to connect, and we'll see. YouTube can't remove your app from phones. Okay, I don't know if that's in connection with the prior one. I'm not techie enough to know really all the connections here, but where continuance is sought based on the late disclosure or discovery of evidence, the alleged tardiness of the discovery must be shown to prejudice the defendant's case so that a fair trial will be denied. Hold on one second. The Bear claim that additional investigation, sorry, I already read that. Additionally, where a continuance sought for potential receipt of evidence, okay, I already read all that, sorry. The defendant argues a continuance is necessary for him to sufficiently review relevant discovery, conduct a full and complete investigation of mitigation evidence, particularly claiming newly revealed evidence that allegedly raises red flags, and remedy the prejudice caused by recent and upcoming inflammatory publicity and the alleged leak of information to the media. Moving forward with the trial, he warns, will violate his rights under the United States Constitution, Idaho Constitution, due process, to free from cruel and unusual punishment, unfair trial, effective assistance of counsel, et cetera, et cetera. The defendant has not demonstrated a continuance is warranted to review discovery. So this is the first part. First, let's check that footnote. Defendant specifically cites the 5th, 6th, 8th, and 14th Amendments. Notably, defendant does not argue the Idaho Constitution provides any heightened protection of the United States Constitution with regard to the rights cited. Thus, the court will not engage in a separate analysis under the Idaho Constitution. I like that. Save us some time. The defendant continues to complain that the state's discovery violations, but to be clear, this court has found no such violations by the state. That's coming here. The defendant contends that the vast amount of discovery in this case renders it impossible for the defense team to review the necessary and relevant discovery in a manner that allows for it to be comprehensively integrated into the defense. He further argues that without any support or explanation, that there are a myriad of issues that continue to arise from the state failing to comply with the discovery and expert disclosure deadlines. The judge is like, well, I don't feel like they've violated anything. A continuance, he argues, is necessary for counsel to mount an effective defense. The court, however, rejected the same argument 2 months ago when the defense sought to strike the death penalty and impose discovery obligation on the state. See order on the defendant's motion to strike the death penalty. In its order, the court observed the utter lack of any proof supporting the defendant's accusations of any discovery violation by the state. So not only is there not a discovery violation, the utter lack of any proof of the defendant's accusations of discovery violation. It's not great. It doesn't feel like he's picking up what the defense is putting down here. More importantly, the court found the defendant's complaints of being unable to meaningfully review discovery entirely unconvincing. Entirely unconvincing. Okay, he's using certain language purposefully, pointing out that counsel struggled to articulate any meaningful way what evidence, let alone relevant evidence, counsel had been unable to review over the past 2+ years, why efforts to facilitate discovery review were not made long ago through this court and or the resource judge. How about that? Defendant's continual reference to a number of terabytes of discovery produced in this case is not helpful without providing a meaningful explanation of what the data primarily consists of and its particular relevance and importance. I agree with that. If they can't articulate it, you can't give it to them. Indeed, as was discussed at the April 9, 2025 hearing, in this case, it appears that most of the terabytes consist of extensive video surveillance from local businesses and residents that show nothing of significance. A lot of times you'll get the time before and after the crime was committed, things like that. In fact, the state indicated at the hearing that much of the discovery is completely irrelevant and stipulated that it is unaware of any Brady material in the video surveillance footage other than that specifically identified in motion practice. Given that the state has identified all its trial exhibits, the defense cannot be unaware of all the incriminating evidence in this discovery. Finally, it should be noted that it was the defendant who early on demanded the state provide all investigative materials, no matter how irrelevant or unhelpful. So that's annoying, right? I don't like judges to do that either, where it's like, You asked for all this irrelevant stuff. It's like, Judge, just because the state says it's irrelevant, even if you think it's a little irrelevant the first time you look at it, Judge, doesn't mean we will with our theories of the defense and how we're going to break down and look at this case. I'm amazed at how many people believe he is not guilty / innocent. Can we have a poll as to where the chat stands now prior to the trial? Oh, no. I hope everybody presumes I'm innocent right now. I really hope that. And if not, I'm going to close my eyes and ears. Not really. I realize how people feel, but right now he's absolutely innocent. Does the state have a lot of evidence? Will the state prove him guilty? Very well may be true. And like I said, there's been some very damning things that have come out about this case, and the experts that are going to be allowed to testify, I think, will be very convincing to some stuff that maybe I don't think is the strongest evidence, but I think the way it comes out in front of the jury, it may feel that way. So we're not going to do a poll right now. We'll do it at the close of the state's evidence. I believe he's innocent until proven guilty. I agree. That's how every defendant should be treated. There's also another Lori Vallow Daybell motion. I have not seen that yet. In your opinion, do you think the defense hasn't had proper time? Feels literally like they've had years. Here's the hard part, right? Because I don't know so much about what's being redacted and done ex parte, it's hard for me to say. From what I've seen, it seems like they should have had enough time to put all this together at this point, but there could be more I don't know about. How can they know if it's important if they can't review it all? Well, that's true, but you can't have infinity days to review things. And if they're still talking about evidence they've gotten years ago, you should have reviewed it by now. Again, I have to speak in somewhat generalities because I don't necessarily know every single thing they've gotten and said in this case because of the obvious redactions. Okay. The defendant's second round of this argument fares no better. He again fails to identify any relevant discovery that his counsel has yet to review. He also fails to identify any steps his counsel has taken, particularly since the court's prior order, to aid in protecting the yet reviewed discovery. Moreover, he does not explain why he waited to seek a continuance until after discovery closed, expert discovery deadlines passed, and the pretrial conference occurred. Because the state said this motion was untimely, you should have done this before. Let's read those footnotes. The only discovery counsel claims that have not fully been reviewed are all of the thousands of tips provided to law enforcement. So first off, for the judge to say he fails to identify any relevant discovery that they've yet to review and then says exactly some discovery they haven't reviewed yet, I don't love that, because why are you putting it in the footnote and saying it doesn't exist when it does exist? Now, you can say the only thing that they have said they haven't reviewed are the tips, and I don't feel that to be relevant. I feel the tips are relevant. I don't know how many they are. I don't know, every wild tip, maybe they shouldn't go down the rabbit hole, but at least look at it. I think the defense is entitled to that. She argues these tips may lead to discovery of evidence of an alternate perpetrator. But again, you have to put deadlines on things. We have to. That's their statute of limitations, their speedy trial rights, right? And to think all these arguments they're making years later that they were actually going to try this case from the speedy trial period, pretty interesting. She argues these tips may lead, the deadline for presenting alternate perpetrator evidence has come and gone, with no motion by the defense to extend it. Further, to offer alternate perpetrator evidence, defense needs far more than an unsubstantiated hearsay tip that another person could have committed the crime. Well, yeah, but that's the point of investigating the tip further. You see how that works? You investigate it further, you get more information, and then that tip becomes an alternate perpetrator. At the hearing on the defendant's motion to strike the death penalty based on his counsel's alleged inability to process discovery, the court suggested several options counsel had to obtain assistance in discovery review. There is no evidence that the defense counsel has exercised any of those options, nor has there been any good explanation of why counsel has not sought additional resources to process and review discovery, such as the tips and security videos. The failure to do so suggests a recognition that this discovery was extremely unlikely to bear fruit. Now, it is true if you wait multiple years to even start looking at something, you obviously might not think it's that important. But again, I don't know. And I don't think judges or prosecutors should tell defense attorneys how to try their case or what's relevant or what's not. All right, back up here. If defense counsel was truly suggesting that with discovery review, this motion should have been made when the claimed problem became apparent, and certainly should have been brought prior to the expiration of discovery, all expert deadlines, etc. So they're saying it's too late. These actions, I don't know what Belly. Oh, Belly. I was thinking that says believe. I thought it was a typo. Belly is counsel's ongoing and ultimately empty discovery complaints. Without more, the court can only conclude that the defense counsel is using the volume of discovery measured in terabytes as a tactic to delay. So he's going to say he thinks this is a dilatory tactic to delay this case at the 11th hour, simply for the sake of delay, rather than a legitimate threat of prejudice to the defendant's substantial rights. Usually judges don't take that swing. They usually don't take that swing, but he took it in this case. Relevant here, too, is the fact that the defendant counsel did not argue for a continuance as an alternate remedy to the defendant's attempt to strike the death penalty because of counsel's allegedly inability to get through the discovery. Again, this goes to the timeliness of when they filed this motion. This highlights that his claims regarding the volume of discovery were used as a tactical sword, untethered to a seriously legitimate concern about the ability to be prepared. This is like going from the top rope as a judge. This is really going from the top rope because he did not need to. This is why it's 20 pages, right? I told you it's kind of unusual that it's 20 pages. This is why it's 20 pages. He wanted to take pot shots. Perhaps even more problematic and more telling is the utter failure of defense counsels now or at any time to specify not only what needs to be reviewed, but importantly, when that review would be complete and the defendant ready for trial. Instead, the defendant seeks an unbounded continuance with no apparent plan to complete the review of unspecified evidence that counsel claims it has yet to review. This is not sufficient to warrant a continuance. I will say, it is a little bit like when Ann Taylor does a continuance or asks for more time, she kind of always makes it seem like I'm never going to have enough time, Judge. I'm always going to need more time. I feel like she's done that multiple times, and I can get why a judge would be a little annoyed at that. Is discovery like you see in Suits, where you get a huge amount of documents hiding in important stuff and you need a Johnny 5 robot to read it all? Sometimes, not always, but sometimes, right? And sometimes it depends on how you ask for it. I want this specific thing. Don't send me 1,000 pages. Send me this specific thing. It all depends on different jurisdictions. Sometimes they'll make you tab it out, say where it is. I'm looking for this, show them exactly where that is. So that depends jurisdiction from jurisdiction. But unfortunately, yes, sometimes it is like that. Is this case going to be televised? I believe the answer to that's going to be yes. By the way, great interviews the last few days. Keep being you. Thank you, Cheryl. And I recognize who you are, even with the weird handle now. Probably a dumb question, but does the judge actually write these documents? They can have the help of drafters or research assistants or certain attorneys that are on their staff. But yes, generally speaking, these are their words. They can dictate it. Somebody else might write it. But this is their stamp. This is their words. Or does a clerk write it under his direction? So it can, but regardless, it's taken as the judge's words. Who cares who, put their fingers on the keyboard? Are you doing recaps of this every day for this trial? 3 months is a long time. So I know there's going to be times I miss because I do have a trial, at least one trial that's in this block, maybe two. So I will be missing some of the stuff there. But we'll see. What do you guys want? Every day, every week, every couple of days? We'll see. The defendant has not established a continuance as necessary to conduct a more thorough life history investigation and identify necessary experts. Defendant next argues he needs additional time to investigate and prepare mitigation evidence, which he contends is necessary to uphold his constitutional rights, particularly those under the 8th and 6th Amendments. Specifically, the defense team claims to be effective, the counsel must conclude an exhaustive and comprehensive dive into the defendant's life history for additional mitigation evidence, analyze the information into a cohesive narrative for the jury, and identify any additional behavioral, cultural, scientific, and or mental health experts may need to develop the mitigation presentation. Despite having hired a mitigation team 2 years ago, defense counsel contends that recently discovered something has raised red flags that the defendant may have something. According to the defendant's primary mitigation investigator, Attorney Blank, her team of 4 have been diligent in their investigation into the defendant's life history, but there have been blank. She believes that with time, she will be able to overcome these barriers by blank. So this is probably some of the stuff that the judge was like, I don't know if I need to redact it. Sounds like it's a good idea because people would take whatever is said here and run with it on the internet to make Brian Kohberger seem like a creep or somebody who for sure did this because of this story and that story. So I think it was good to redact these. But again, we're not getting a ton about what it is. The defendant has not demonstrated continuance to accommodate further investigation is constitutionally required. I will say this stuff, they've known about this for a while. I think they should have gotten this information. The amendment, or tell me I need 1 month or 2 months or whatever, requires that a capital defendant be allowed to present all relevant evidence of mitigation. The jury must be allowed to consider all of a capital defendant's mitigating character evidence. In addition, a capital defendant has a Sixth Amendment right to a fair trial and effective assistance of counsel in both the guilt and penalty phases of a capital case. As the defendant points out, defense counsel is constitutionally required to conduct a thorough investigation and preparation of a penalty phase of a capital case. Presentation of some mitigating evidence, even if strong, is insufficient if other mitigating evidence is available upon reasonable investigation. Because again, the definition of what is a reasonable investigation is paramount here. The assertion that counsel needs a continuance for an exhaustive and I already read that. For additional counsel's investigation and mitigation must be reasonable. Idaho court and United States Supreme Court hold that the defense is not required to investigate the defendant's entire life in order to present a constitutionally sufficient mitigation evidence. I would agree with all this. I would agree also, it's kind of like checking a box as a defendant saying, we need more, we need more, we need more. We emphasize that Strickland does not require counsel to investigate every conceivable line of mitigating evidence, no matter how unlikely the effort would be to assist the defendant in sentencing, while the defendant notes that the ABA guidelines for mitigation function of a defense team to a death penalty case urge counsel in death penalty cases to conduct an ongoing, exhaustive, and independent investigation of every aspect of the client's character, history, records, and any circumstances of the offense to meet their constitutional obligations. Courts look not to what is prudent or appropriate, but only to what is constitutionally compelled. So we're saying the case law says it should be robust, if I may pull a word from Judge Cannoni's vocabulary. Rejecting argument that heightened procedural safeguards should be employed at discovery in capital cases. Roe, a capital case, is instructive here. On post-conviction, Roe argued her counsel was deficient because they failed to perform an adequate investigation into Roe's background in search of mitigating evidence. Specifically, Roe argued counsel should have investigated her life from birth to sentencing. That counsel were deficient in presenting her mental health workup. The counsel rejected this claim, holding that counsel was not required to investigate Roe's entire life in order to objectively and reasonably present Roe's mitigation evidence. The court further noted that great lengths counsel underwent to investigate the present mitigating evidence from several of Roe's friends' health and welfare records, letters from friends and family, and Veterans Administration records concerning Roe's husband, previous injuries, and the couple's relationship. The investigation defendants experts have undertaken over the past 2+ years far exceeds that in Roe, and in fact, readily appears to satisfy the relevant ABA guidelines cited in the defendant. It includes, but is not limited to, and then he lists everything they've looked at. And what I'll say is, again, being a good lawyer is often held against you. And he says, look at all the stuff they've done. They have done their due diligence. Look at what a good job you've done. You don't need more time. I'm starting to think that like when I read these documents is when I start to get so hungry. I don't know what it is, but I'm like starving right now. Are we biased in the chat? If this was denied in the Karen Reed trial, would we be up in arms? But here we say the judge made the right choice. I think it all depends on how you look at it. And I would say that the lawyers in this case have done such a good investigation from my perspective that I understand where the judge is coming from. The third party culprit, it's hard for me to say whether the judge made a good call or not because so much of the important information is redacted. That's the hard part for me here. But also, the motion to continue in Karen Reed's case, to me, was way more rushed than this case on what hadn't been done yet and the timing of it, the first trial. If you remember, they both wanted to continue that case and the judge denied it. Third party culprit, I don't know. I need more information in this case. Peter, I disagree. AT can't have it both ways, wanting all discovery, then ask the state to point out what's relevant because it's too much. No, I don't think she's asking the state to point out. I think that was a different question. I don't think Ann Taylor is asking the state to point out what is relevant. If his lawyer is a public defender, will she have other cases? And could that be why it's taking so long? I don't know if something's changed, but I heard she was dedicating like almost all of her time to this case. That was early on, so something could have changed. In my opinion, it is not unusual for this type of case to take this long to come to trial. I agree. Not at all. Not at all is it unusual. It's unusual, frankly, the amount of work that's been done in these years, because all 3-year criminal litigation is not the same. Some lawyers do absolutely squadoosh in 3 years, and that's where it becomes a problem. I would love to know Michael Easter's involvement in this case. Peter, belie a point. I swear I'm going to write the What the Lawyer You Know dictionary. Lawyer don't know. We all do it. Even Peter laughs about it. It happens all the time. Happens all the time. Give grace, relax, right? Everybody relax. By the way, people pronounce things differently. They do. And I love corrections. I love to use them. Hopefully we will not belie the point here. Okay. Educational records, coursework, interviews, mental health, medical records, car accident, employment records, mental health, education, employment records, defendant's sisters, parents, military records of the dad, social security records, et cetera, et cetera. You see everything they've gone through here. It is evident from the reports of the defendant's mitigation experts, Dr. Orr, Dr. Ryan, Dr. Brahms, that they have developed an expansive understanding of the defense family. It's a little bit weird that they blocked out the lawyer's name. That's one of their experts, right? Environment, social development history, family history, both nuclear and extended over multiple generations, educational history and mental health and medical history. From this evidence, these experts have rendered several current diagnoses and identified other diagnoses for which the defendant met criteria at some point in his life. Despite such an extensive investigation, defendant claims additional investigation is warranted to identify, and it's blocked out. However, he's not established that such investigation is constitutionally compelled. Again, there's too much blocked out to even know what the context is here. As noted, a continuance for the trial is not warranted to chase down mere speculation that potential evidence exists. Further, the defendant has not set forth a plan for continued investigation. And we've talked about this in the past, how if you tell me how long you need, usually that's helpful. How much time will take, time it will take. What has a team, by the way, the trial I had that was supposed to start in June, the beginning of this week, that's been pushed to August. One of the reasons it got continued is because the lawyers exactly did that. They said, we only need until August. It's short. Here's what we need to do. And I objected, fought against it, but it still ended up happening. When you give a time period that it's short, then it gives you a better chance to win. Additionally, assuming guilt is found, the penalty phase of the case will not begin until late October or early November. Thus, there remaining significant time for that lawyer and the team to continue. And he's right about that, where if the guilt phase people are not trying the case, they have that time to continue their investigation. So I like that point that he made. Okay, I'm just going to skip this stuff. Attributed his own mitigation experts to his ASD, OCD, or ADHD are consistent with childhood trauma, and there is evidence of poverty, both generational and family. Again, a lot of this is being blocked out. Notably missing from blank declaration is an indication as to how she intends to confirm her suspicions or how long she expects it to take, be that months, years, or even decades. Exactly. If you need another 5 years, we ain't doing that. The defendant's family has likewise been extensively interviewed, and there has been no report that, I don't know, again, a lot of this stuff, it's hard to even tell what's going on. So much of it is redacted. All this information has been available and documented in the record for months. Okay, so that's not going to help you out if you're the defense and the judge is like, you've had months to do this, why haven't you done it? Yet again, the defendant is only now moving for a continuance for further investigation into something unsupported suspicious smacks tactical game. This unsupported suspicion smacks of tactical gamesmanship and delay. Yikes. What was that noise? That's not good. That's not good. Well, it's unreasonable for the court to continue trial indefinitely for, again, we don't know. Counsel's argument that more time is needed to investigate whether something likewise squarely unsupported. So he leaves that in there. He's like, regardless of what the argument actually is, it's squarely unsupported. I mean, he's harshly denying. It's like when certain lawyers, I am strongly objecting to this judge. He is strongly denying their motion here. Nevertheless, who again, not even marginally qualified to opine. I mean, he's saying these experts are not even marginally qualified to opine on this. He used the word unearth. That's kind of interesting, right? Need additional time to unearth it. In Karen Reed's case, a lot of evidence took time to be unearthed. Again, not one of the defendant's experts who have had time and information identified have submitted declaration that they may change their diagnosis based on further investigation. Rather, it is based on speculation that further investigation might change certain things. Such speculation is not grounds for continuance. Not only is there lack of support in the record, anticipation that more investigation change their minds. Not indicated the plan they have to obtain this information or how long it will take. He hammers the how long it will take over and over again because that's a big deal in these motions to continue. In sum, the defendant has not demonstrated that a continuance for further investigation into potential mitigation evidence is necessary to uphold his constitutional rights. The right to present mitigation evidence and the right to effective assistance of counsel do not necessitate an investigation of the entire history. They simply require that the investigation be reasonable, while easily available mitigation evidence cannot be ignored. The defendant's briefing demonstrates that the evidence they are attempted to obtain is far from easily available and, in fact, may not even exist. So he's saying if this falls so short to the easily obtainable standard. Further, the evidence prompting the need for further investigation has blank been available for months, yet it is only now the defendant seeks a continuance. Well, on the flip side of that, it's like, hey, I tried. We tried to do it in the time period and we couldn't get it done. That's why we're here now, Judge. This tactic seems geared toward achieving delay rather than a good faith effort to obtain meaningful mitigation evidence. Like, bro, we get it. We get that you think this is a tactic to them or for them. See, once of this, I think, is on the defense for not being specific as he's requested them to be repeatedly. So I get you're saying that it's on the defense, Sleuthy. And that's one way to look at it. But I will say on the flip side, it could just be that the judge is right and that they're not being specific because they can't be specific, or if they are specific, they know they're going to lose. And that's, I think, how the judge is taking it at this point. So it's either the defense not doing a good job. It's like, hey, he said be specific and you're not being specific, you're going to lose. Or they can't be specific because they lose if they're specific, or there's nothing to be specific about, and it is just a delay tactic. That could be true. He is saying it every time, and it could still be true. My beard is like, or my mustache is tickling my nose so much, I can't stop. Like, it's annoying the crap out of me. Maybe a little TMI. We're at the hour mark, so we could stop. We have 1, 2, 3, 4, 5, 6 pages left, or we can just knock it out if everybody hits that like button. What do you guys think? Should we knock it out? I'm just kidding. Of course, we're going to knock it out, but still hit that like button. Just sent you the article on Instagram that Karen Reed and AJ signed a deal for the on-screen adaptation of the case. Wonder what that's going to look like. Is that a legitimate like movie, like big budget movie? I'm interested. All right, let's ride. We ride at dawn here. Let's do it. Moreover, the defendant provides absolutely no plan for how further investigation will proceed, who will be interviewed, or how long it will take. The Constitution does not demand that this court is not willing to continue the trial indefinitely to allow the defense team to embark on their fishing expedition, pulling at every conceivable thread in defendant's familial tapestry. Counsel's assertion that they will be better prepared with more time and more evidence is an assertion shared by every lawyer involved in a trial. He ain't wrong. At some point, and particularly after 2.5 years of investigation, the defense team must be satisfied with what they have, which in this case is extensive. In addition, while the crime victim's rights to a timely disposition under Article 1, Section 22 do not trump the defendant's right to fair trial, they provide an additional justification for proceeding with the trial as scheduled. I love that. We can't forget the victims, and while their rights don't trump a defendant's right to a fair trial, we have to consider them, and at some point, we got to do it. We got to do this. A continuance is not warranted due to pretrial publicity. Okay, good. This was one of the more interesting parts of this motion to me, and this is kind of what makes this case different than every other criminal trial where they file a motion like this. The defendant next seeks a continuance due to recent inflammatory pretrial publicity. 3 months ago, trial was set to begin. Dateline NBC aired something. The episode included details material to the case, which, if true, are not publicly available and promote a narrative of guilt. It advises Amazon Prime is planning to release a 4-part series Crime author James Patterson is set to release his book. They contend the media coverage threatens the right to a fair trial. The court does not agree that either argument compels a continuance. Oh, they also say that we want to investigate the leaks, which we already know. We talked about that a lot. The Sixth Amendment to the United States Constitution affords all criminal defendants the fundamental right to a fair trial. This includes the right to have impartial jurors that know as little as possible about the case. Not nothing about the case, which some people confuse it to mean, but as little as possible. To decide the defendant's guilt based on material admitted into evidence before them in a court proceeding, uninfluenced by extrajudicial statements. A trial judge has an affirmative duty to minimize the effects of pretrial publicity. In Shepard, relied on by the defendant, the United States Supreme Court recognized that the adverse effect of inflammatory publicity has on the ability to obtain an impartial jury, strongly urged trial courts to act quickly and forcefully in addressing such publicity. The court further advised that where there is a reasonable likelihood that prejudicial news prior to the trial will prevent a fair trial, the judge should continue the case until the threat abates or transfer it to another county not so permeated with publicity. They've already delayed and they've already changed the venue. So the judge is going to look at this like we've already hit some of these remedies, okay? So make sure you understand that, and that's going to be taken into account in the judge's decision here. However, this statement must be read in context. The media coverage that in that case is far different from that present here. In Shepard, news reporters extensively covered the story of Sam Shepard, who was accused of bludgeoning his pregnant wife. The court examined the extensive media fanfare surrounding the case, noting Shepard was not granted a change of venue to a locale away from where the publicity originated, nor was his jury sequestered. For months, the virulent publicity about Shepard and the M had made the case notorious. Charges and countercharges were aired in the news media besides those for which Shepard was called to trial. In addition, only 3 months before trial, Shepard was examined for more than 5 hours without counsel during a 3-day inquest, which ended in a public brawl. The inquest was televised live from a high school gymnasium seating hundreds of people. Furthermore, the trial began 2 weeks before a hotly contested election at which both Chief Prosecutor Mahon and Judge Blythen were candidates for judgeship. The court found there was no doubt the deluge of publicity reached at least some of the jury. Given that when the jury was questioned for the only time, 2 jurors admitted in open court to hearing highly inflammatory charge that a prison inmate claimed Shepard was the father of her illegitimate child. Nevertheless, the trial judge rejected requests by the defense counsel for the jurors to be asked whether they had read or heard specific prejudicial comments about the case. Further, the jurors were subjected to newspaper, radio, and television coverage of the trial while not taking part in the proceedings, and were allowed to go their separate ways outside the courtroom without adequate direction, not to read or listen to anything concerning the case. I mean, how many times can the ball be dropped with regard to publicity in one case? It seems like it happened over and over again here. And the judge, what he's doing is differentiating Kohberger's case from that case, saying it's very different here. Bedlam reigned at the courthouse during the trial, and newsmen took over practically the entire courtroom. The court reversed Shepard's conviction. Crucially, the court stated that although the pretrial publicity alone was not sufficient to warrant relief, when combined with the carnival atmosphere the press created at trial and the judge's inability or lack of desire to control the courtroom proceeding, Shepard's right to a fair trial was denied. Pretrial publicity, even pervasive adverse publicity, does not inevitably lead to an unfair trial. If months of virulent pretrial media coverage was not enough to deny due process in the Shepard case, it is certainly not enough in this case, where media coverage has been far less pervasive. In addition, the court is employing the measures recommended in Shepard to protect the defendant's right to pretrial publicity, to wit, limiting the number of reporters in the courtroom, insulating the prospective witnesses from interviews with the media about their prospective testimony, making an effort to control the release of the leads, information, and gossip to the press by police officers, witnesses, and counsel for both sides, to avoid disclosure of inaccurate or inadmissible information to the public. Gag order, changing venue. They're doing things in this case, instructing people not to talk about it, signing NDAs when certain discovery is given over. They're doing things in this case that were not done in Shepard. Who redacts the motions? Is it only the judge or an agreement of both parties? the judge usually is the one redacting the motions. If the diddler can seat a jury, this case can for sure. I would agree with you. All right. Ultimately, whether the defendant can receive a fair trial depends on whether the fair impartial jury can be seated. As the United States Supreme Court said, to hold that a mere existence of any preconceived notion as to the guilt or innocence of an accused without more is sufficient to rebut a presumption of prospective jurors' impartiality would be to establish an impossible standard. It is sufficient that the juror can lay aside his impression or opinion and render a verdict based on the evidence presented in court. Ugh, strike those jurors that have preconceived notions of guilt. Accordingly, the Idaho Supreme Court has long recognized that trial courts can successfully select an impartial jury despite widespread publicity. Extensive publicity prior to trial deprived certain people of the opportunity to be tried before an impartial jury because each juror was extensively questioned to determine the degree of their exposure to the pretrial publicity. The court found the defendant's rights were preserved. In the defendant's subsequent habeas case, they're talking about another case. Ninth Circuit examined at length the entire voir dire process and found no prejudice, even though on the day of jury selection, the case was covered on the front page of the local newspaper as well as TV and radio. With the measures the court has already put in place to protect the defendant against pretrial media coverage and the court's carefully crafted jury selection process, there is no reason to think that an impartial jury cannot be selected through a searching and robust voir dire. In addition, while continuances may be appropriate if pretrial scrutiny is reasonably expected to fade with time, it is an ineffective tool where publicity is such that there is no reason to anticipate it would subside by any delay, which would not push off the trial indefinitely. We knew that was going to be a big point. If we don't do it now, then are we going to be at the mercy of the media to just stop talking about this case? The denial of a motion for an indefinite or substantial continuance predicated on widespread adverse pretrial publicity about a defendant is all the more warranted when, as here, there is sound reason to believe that the defendant will continue to be a controversial, publicity-invoking figure, and hence that there is little assurance that the passage of time will result in an abatement or subsidence of critical publicity in the foreseeable future. The court observed that the Sixth Amendment's guarantee of a speedy trial is one to which the government and society, as well as the accused, has a claim, and stated society cannot be utterly deprived of the right to prosecute and try someone for a crime within a reasonable time merely because of widespread community knowledge. I don't really love citing this because you have to be really careful when you compare this with the defendant's Sixth Amendment right, which is a much more important right. Here, there is no assurance that the pretrial publicity will fade with time. The crimes occurred over 2.5 years ago. The circumstances of the crimes were provocative. 4 college students in a small Idaho college town were brutally ended their life by an unknown perpetrator. Is he saying it's unknown? I mean, unknown to us, but was it unknown to the victims? It was an immediate media sensation and garnered widespread attention. I agree with that. That not only continues to persist, but continues to grow. I don't know if I'd say it's grown over time. It was pretty big right off the bat. 18 months ago, the defendant moved for a change of venue. We knew this was going to come up due to this publicity, and it was granted. They had to leave Latah to avoid the bias. And again, we knew that was going to be held against them in this motion. Those additional 10 weeks have not resulted in fading media attention. It has only given the media more time and opportunity to provide coverage to a public audience, which is clamoring for answers. The longer the public is made to sit and wait for the facts to come out at the trial, the more time there is for inflammatory speculative stories, movies, books to circulate, and more time for prior ones to be rebroadcast, purchased, viewed, and consumed by the public. Proceeding with the trial as scheduled will likely avoid negative consequences from future publicity. Thus, the court finds a continuance is not warranted based on the media coverage. Rather, careful and patient voir dire is prescribed. So he's saying we're going to fix this in jury selection. Continuance is not warranted to investigate the leak. The defendant also asserts continuance warranted accountability. With regard to the Dateline episode, the defendant points out the Dateline represents material came from sources close to the investigation. Okay, we already kind of been over this. Based on over 300 interviews, several individuals, including the victims' families and law enforcement. He also notes that the Amazon Prime docuseries promises to be captivating, tense, and emotionally retching detail by only those in and affected by the crime. He argues that if any of the leaks came from witnesses the state intends to call or from others involved in the investigation, that information is Brady material. I agree, because it would serve to impeach the leaker's credibility and may be exculpatory. I agree with that. He adds that if the investigation reveals that other state agents had information about the leaks but failed to disclose it, this omission would constitute Brady violation. So one thing I would push back on the judge is get a special prosecutor, give them 3 months to investigate. Let's do a 3 months continuance, and then we can do this. If you want to be specific and put time limitations on it like Sleuthie asked for, I do think there is some opportunity there. Do you think the judge sounds pro-prosecution here? Honestly, if I was going to just guess, he kind of seems more anti-defense or anti-this defense or defendant more than he does pro-prosecution. I don't know. As noted, no, I agree that he doesn't agree with it. I'm saying I agree with the defense and disagree with the judge here. I disagree with the judge. I agree with the defense with that argument. As noted, a continuance is not warranted where the information sought thereby is merely speculation. I mean, it's speculation that there is a leak, but it's not speculation that if there is a leak and they're going to be a witness, that's a big deal. That's not speculative. That's legit. The Brady argument is built on a house of speculative assumptions. An assumption that there was a leak by persons bound by the non-dissemination order. Seemed like the judge was not too happy about that possibility. An assumption that the leaker will be found. I agree with that. An assumption that the leaker were law enforcement. It's not just law enforcement. I think it's not an assumption that the leaker is going to be friendly to the state and that would be exculpatory potentially for the defense. An assumption that the leaker or others who may be complicit will be testifying as a government witness, whatever. And as an assumption that these witnesses will likely be material. Such assumptions are not grounds for a continuance, particularly given that there is no guarantee if and when they will be confirmed or debunked. This trial cannot be held hostage indefinitely to the outcome of the investigation, particularly given the very significant chance the leakers may never be discovered. Thus, the court will not continue the trial pending the result of an investigation based on speculation that it will be successful and the hope that impeachment evidence will be uncovered as a result. So here's what I will say. Of the entire motion, because the pretrial publicity, I agree. When is that going to stop? We don't know. That could be going on forever. Of the entire motion, if we later find out the leaker was a bunch of people that end up testifying for the state and the defense was not able to ask them and question them about their conversation and involvement on pretrial publicity that was all bad for the defendant that came out right before trial, that's a legitimate appellate issue. That is a legitimate appellate issue. And I think, frankly, the best one in this entire motion. Oh, here we go. Should have known the smart chat was going to pick up on it. I think that's a legitimate appellate issue, yes. How do they determine where the trial will be transferred to when there's a change of venue? How was it determined who the new judge would be? So the new judge, I think, was the next one on the list appointed by, that was appointed, but where they kind of compared counties and gave options, and then that's where it went. It's usually the same one, the bigger counties. The Vallow-Daybell cases were held here as well. All right. That's it, folks. Tell your friends that are following the Kohberger case, if they're interested and they want to come hang out, talk about the case, let them know to come here, hang out. Let me know what they think about it. I'd love to have them. That's all we got for this one. I got to go eat. I'm hungry. Hit the like button, subscribe, do all the YouTube-y things. I'm out of here. Appreciate you guys hanging out. I'm going to be going to Greece soon. I'm going to miss hanging out with you, doing these lives. So let's hit as many as we can before we leave. Peace. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.